video is an introduction to the 4 assessment tools that were designed to accompany our report, AI for Justice, Ethical, Fair and Robust Adoption in India's Courts. This project is a collaboration between DAKSH, a Bangalore-based civil society organization working on judicial reforms, and Digital Futures Lab, a Goa-based research studio that conducts work on technology and society and has a body of work on AI governance. This project has been supported by the UNDP office in India. In our report, we took a look at how AI adoption is being thought about within the judiciary and what a governance framework for this could look like. We conducted interviews with stakeholders from the judiciary, legal practice, policy, and technology, and looked at global governance frameworks such as the EU AI Act, NIST Risk Management Framework, and a variety of national regulations around use of AI in the public sector. Our assessment tools are Excel-based decision support frameworks that courts can use to evaluate, adopt, and monitor the use of AI. These have been developed for Indian courts and therefore take a right-centered approach, not one that purely focuses on technical risk. Why did we create these tools? Our research looked at the policy gaps in this ecosystem and threw up a series of questions that could be asked either by various stakeholders or by involving them at a particular moment in time. These involved identifying risks that could emerge from AI use, asking solution providers about the tools that they built, including what information it was trained on, what role AI or ML plays within the tool, and what technical guardrails they designed, as well as institutionalizing safeguards to mitigate risks on a continuing basis. Our framework grew out of a risk checklist exercise, but it took features of a fundamental rights impact assessment on as well. We included additional questions that considered how use of AI could lead to bias against particular litigants or violate rights, such as the right to privacy, a right to freedom of speech, association and protest, rights of minorities and protected groups, right to liberty, procedural rights, and fair trial rights. To envision potential harms from AI, we considered 4 dimensions. 1, the actual function or use case which AI would be deployed in, whether this was judicial or administrative, and how it's being done currently. 2 is what areas of law or legal domains AI would be integrated with, and if they had any specific sensitivities. 3 is what the proceeding type was, whether the interaction would be in open court, in a registry office, or even in a judge's chamber during preparation for a hearing or for judgment preparation. And 4, what litigant types could be, whether they would involve protected groups or groups like minors, which have specific vulnerabilities that must be protected against. Our 4 tools work together. The first one looks at institutional readiness, that is technical equipment, training and upskilling, and having the right regulations or policies in place prior to introduction of AI. The second looks at risks and safeguards that could be identified within the specific use case or function. The third could be handed over to developers entirely and asks technical questions about how the tool works and the sustainability or integration of that tool. And the fourth looks at ongoing assessment, or what performance, impact, and sustainability could look like in the long term. These tools are designed to be used together. The recommendations or suggestions from each tool flow into the next, where the institutional readiness looks at the necessary preconditions, the risk assessment is a weighing of risks and possibility of harm in context. The technical assessment provides closer visibility into how AI works, and the ongoing monitoring provides a framework for a governing committee or an oversight authority to monitor the tool's use over time. Finally, each tool ultimately gives a recommendation, whether to proceed with AI use or to pause and take certain steps for mitigation before moving along. Each of the 4 tools that we've created has roughly the same structure and has the same 4 tabs: the instructions, the questions, the summary, and the response validation. So the first tab for each tool includes what the tool covers, the rationale for having these tools, the actual instructions that should be carried out in order to fill up the tool, and it includes a clustering of the questions that are present in the tool by category, as well as how many questions are present in each and how many of these are non-scoring questions. Also within this diagram, we illustrate where in the sequence of decision making for AI interaction this particular tool would come. In this tool, we are looking at the kind of the use case level risk assessment. So the questions are set up in such a way that as much as possible, they are drop downs. Every yellow tab is a drop down. And then see this question as an example, how will the use case influence or impact judicial functioning? Based on how many of the actual elements a court user might fill up or find the answer is yes to, they may decide which of these is the most relevant or is the most appropriate for that use case. And this can go from AI is used for a peripheral or a general purpose, which would return a low risk categorization, or something more high risk, which is AI would advise on substantive legal issues. Along with this particular drop down fill up and risk level or action return kind of recommendation, we also have included a section which includes an explanation as to how relevant each question would actually be and why we believe it's an important one to ask at this level. The fourth tab, it provides visibility into the drop down and the response returned for each question and gives an exact visibility into how that's filled up and what is returned. And the summary tab is where you would find the final recommendation of the tool. So by the same categories that are present on the first tab, the instructions tab, the questions for each, the response that is actually filled up within, and the account up of what the responses are. And in this instance, there are two ways that risk could be identified. One being simply from the answer to question 2, which is a low risk or a high risk or a medium risk response, with the fourth option being high risk recommending prohibition. And the other thing is based on how many of the questions in the middle return either may proceed with AI or do not proceed with AI without taking certain steps. The tool provides a place for the user to think about what steps might be taken to mitigate that situation before moving ahead with AI. And as the diagram that shows the 4 tools together mentions, it shows what initial safeguards would be recommended from our perspective in order for AI to be used in that use case. A similar structure is followed for the other tools as well. The third tool has a similar structure. This technical assessment includes the rationale for the tool, the instructions as to how it should be filled up. This tool is different from the other 3 that we've created in that it's to be filled up by the developer or the solution provider, whether they're a private startup, a joint venture of some kind, the in-house technical team, a public university, etc. It shows kind of where in the sequence of decision making this tool would come. And then the other major difference for this third tool is that based on whether the risk tiering suggests that the use case is of a medium risk or a high risk level. If it's a high risk level, we've identified 58 questions across these categories, of which 15 are non-scoring. If it's a medium risk, then we've pulled out a subset of 39 questions from this pool, of which 8 are non-scoring. So some of the questions have been removed if it's a medium risk to proceed and move ahead. The questions under each of these, the questions under the high risk or the medium risk are separated and fall kind of across these same categories. The business model or the company itself, or the entity that's providing the tool, what the tool is actually doing and how artificial intelligence or machine learning are being leveraged within the tool, how the tool could impact rights. So for example, against equality and non-discrimination, whether we think it would have little to no impact, moderate, high, or very high. There's a question on the training data that the model or the actual tool would be trained on. and how that is documented as well through data cards or logs. The model design, who developed the model, who was engaged with during the model's development and testing, the visibility, such as the interpretability and explainability of the tool's outputs, and many of these questions, as you can see, are marked as non-scoring. They are purely designed for an informational advantage for the court in evaluating tools that come to them. So these questions can also be used to inform a procurement level exercise through a checklist or any other parallel document. The auditability of how the tool is actually used and how it would be integrated, and the system safety once it comes in. So when, for example, the use of the tool would stop if incidents were reported, as well as regulatory compliance in whatever frameworks exist within an Indian context. When you take the high risk kind of summary tab, what's happening is per each category, the number of scored questions and the score that's being generated is being counted up and is giving a score. As long as this score exceeds 60%, we believe that the tool is passing a basic threshold that can be moved ahead with. If this number is below the 60% threshold, you can see which category of questions is pulling that score down. And so the court can either ask a specific solution provider to work on that area, or the solution providers can in and of themselves strengthen the tool's performance in that way. As we mentioned, of the 58 questions that are there in the high-risk tool, a smaller list of them are provided here for the medium risk. And what's worth mentioning is, again, out of the total number of questions and the scored questions within that, a great percentage of them have a binary response that would yield either a 0 or a 10. So that becomes a simple yes or no question. It's not one that is requiring kind of a great deal of information creation or placing an onerous burden on the solution provider. So this is one tool where we specifically are looking for feedback from especially anyone involved in the design and the development of AI tools that are being generated for a judicial context in India. Please do get in touch with us if you have any feedback on how many of these questions might be relevant and how to think about them moving forwards. At this point, we've created initial drafts of these 4 tools based on some feedback from our initial consultations, but we're currently seeking further feedback and refinement or a rationalization of how many of these questions are actually useful for courts as they move forward and think about the integration of AI. If you're a court user, if you're a developer or a researcher or someone who's just thinking deeply about the impact that AI could have on our society, please feel free to write to any of us at DAKSH Digital Futures Lab or UNDP India with any thoughts or feedback you may have. The 4 tools are available on all 3 websites. Thank you so much.